In this lecture, we're going to talk about conflicts of interest for lawyers, and a very specific one under 1.8D. This is about taking literary rights to your client's story or the story of the representation in lieu of fees or during the representation. So you can't, and our basic rule is going to be you can't do that. You can't accept literary rights in the client's case. Just as a quick recap, 1.8, Model Rule 1.8 in the ABA's Model Rules is a group of rules that relate to the lawyer's own self-interest that can create conflicts of interest with clients. And the most extensive one is really 1.8A, which covers all sorts of business transactions with clients. And then with the rules, some of the rules are very specific, and 1.8D is a specific one about lawyers asking for literary rights in their client's case. And here's our rule. Prior to the conclusion of representation of the client, a lawyer may not make or negotiate an agreement giving the lawyer literary or media rights to a portrayal or account based in substantial part on information relating to the representation. Keep in mind that sometimes your clients, especially, this happens more in litigation, as you might expect. We don't have a lot of clients, a lot of lawyers asking for literary rights for a simple transaction like drafting a contract. But for litigation rights, a lot of times clients don't have money to pay their lawyer up front, and so they will assign, and sometimes historically lawyers would suggest, why don't you assign me the book rights and the movie rights, because this is going to be a high profile case or an exciting case or something like that, and they'll take that in lieu of fees. And we have a rule against it. Please note I put in bold prior to the conclusion of the representation. So you cannot do this during the representation. Note that this means, and this could be a gotcha question on the MPRE someday, this implies that suppose you've completed the representation for the client agreed to pay you traditional fees like money, and then after the representation is over, when you send the client the bill, the client says, I now realize I'm never going to be able to pay this. Could I just assign you the literary rights or the media rights to the case? And because the representation is concluded, you could permissibly then accept a conversion of your outstanding bills, the outstanding fees the client owes you, into the form of the media rights, the assignment of media rights. Let's go to the comments. Comment 9 to Rule 1.8 addresses 1.8D. An agreement by which the lawyer acquires literary or media rights concerning the conduct of the representation creates a conflict of interest between the interests of the client and the personal interests of the lawyer. Measures suitable in the representation of the client may detract from the publication value of an account of the representation. Now, I want to pause for just a moment and have you think about, as a student, what are we talking about? What could possibly go wrong if you know that you own the book or film rights to a big case you're working on? Well, one of our gravest concerns is that when your client has an opportunity to settle the case instead of going to trial, you have a perverse incentive to say, no, let's go to trial. Why? Whoever made a movie about a case that just settled right away, right? And that's not exciting at all. And that would be a really thin book. And so, no, you want the trial drama, the people yelling, objection, Your Honor, the jurors gasping in horror and disbelief at shocking testimony from witnesses. That makes great television. And that brings us to our next point. Not only are we afraid that you will encourage your client to turn down a settlement offer or a plea bargain that they should take, but we're afraid that you're going to kind of yuck it up at the trial or ham it up because you're thinking the more drama that we have, the more this sells, right? The higher the value the story is. And so you may be tempted to make the trial more sensational and shocking than it needs to be, and that even if it's not always in your client's best interest. And and so the dramatizing, sensationalizing things often is bad for your client. But if you know that you have a financial stake in this, how exciting the story is and how memorable the trial is, then it creates all sorts of perverse incentives for you in the representation. How common is this? In the last decade, we had a US Supreme Court case about this where a criminal defense lawyer had done this, and the Supreme Court said it's an ethical violation. It's a conflict of interest to take literary rights in the case, so that means it's ineffective assistance of counsel. Sadly though, under the Strickland test, it did not do the defendant any good in obtaining a reversal of their conviction, because the Supreme Court then held that even though it was a conflict and that counts as ineffective assistance, it didn't prejudice the proceedings. Okay, let's go back to the comments for a moment, shall we? Paragraph 9D does not prohibit a lawyer from representing a client in a transaction concerning literary property from agreeing that the lawyer's fee shall consist of a share in the ownership of the property if the arrangement conforms to 1.5 and paragraphs A and I. And so if you're a little lost at what that's saying, let's say that you are representing someone in a copyright infringement action, and because they're claiming to have committed plagiarism. And so this could be over a book, but I'll give you a couple of cases. Let's say we have, you're representing George Harrison from the Beatles, who had a copyright issue with one of his big hits after the Beatles broke up. And you're representing him. Is this really his song? There's someone else came forward and said he stole the song from a song from 15 years earlier that was another hit. The melody actually is kind of the same. And so the question is then, can you, and George Harrison says, look, I'm down on my luck, I don't have any money, but I'll give you some of the royalties. I'll assign a share of the royalties of this song if you'll handle the case for me, and we win. We have another artist who's kind of been popular in the last few years named Robin Thicke. I'm not a fan and couldn't name any of his songs, but there was a copyright, an accusation that he had stolen somebody's song. And so again, can he assign, if he can't pay his lawyer, can he say, I tell you what, I'll assign some of the royalties, assuming that we win, to you in lieu of fees? Yes, because you're not accepting literary rights in the story of the case, you're accepting literary rights in the race, the underlying art that the case is about, and that's different. Now, do keep in mind that you're still going to have to comply with the rules about fees for 1.5. So we can't, this is a case that's going to take 1 hour of your time to settle, you can't, or it's going to be unreasonable for you to accept a royalty share that's going to pay you $10 million over the next few years. And similarly, paragraph A points out that if you're accepting an assignment of rights like property or intellectual property rights in lieu of fees, not only does it have to comply with the rules about fees, it also counts as a business transaction with the client. And so you have to do all the written disclosure requirements and get the client's signature on one of them that are required under 1.8A. Okay, here's a couple of quick cases just for fun. 2006, we have a Massachusetts case where a defense attorney had agreed with a television company to wear a concealed microphone during a murder trial. And unsurprisingly, on appeal, the court held that created a conflict of interest and ordered a new trial. Now, notice that wouldn't necessarily be true under the federal rules with the Strickland test, but the Massachusetts appellate courts said that this warranted a retrial. We have Harrison versus Mississippi Bar from 1994. This was, again, a lawyer's agreement with a film producer for rights to her life story, including a section on the representation of the current client, the lawyer's representation, and that violated 1.8D. And so keep that in mind, that if your client is assigning you their life story, but a big part of their life story is about the litigation, the big case that they had that you did for them, then that, even if part of it is about the case, then you have violated 1.8D and you would be subject to discipline by your state bar. Okay, here's our quiz question for attendance. If you ever need to document that you watched this video, you can just email me the answer or just keep it for your records until it comes up. True or false? If a client cannot afford to pay the lawyer's fee at the time of representation, the lawyer may accept an assignment of the client's literary rights in the story of the case as payment instead. True or false? Hopefully you know the answer to that after listening to this video. If you're stumped, you better go back and watch this again, because I think we made that pretty clear. That concludes our lecture.